Now it is time for the last word with Lawrence O'Donnell. Good evening, Lawrence.
Good evening, Alicia. We just got the transcript from today's court session, and so Andrew Weissman and Adam Klasfeld are here to read it. I won't obviously have the time to do that. Neil Katyal is going to be joining us later in the hour to consider what happened in the Supreme Court today, so we have a lot to get to here.
So much breaking news. Good to see you, Lawrence.
Thanks, Alicia. Thank you. Well, when Donald Trump lived in the White House, he usually wouldn't come down from the residence to the workspace in the West Wing until around 11 a.m. And when he got to the workspace in the West Wing, Walt Nauta, who is now a co-defendant with Donald Trump in Florida, would have Donald Trump's caffeine doses ready for him in the form of Diet Coke, constantly handed to Donald Trump, often without needing to ask. But as a criminal defendant, Donald Trump has to get himself dressed and in the car so that he can get to his new job in Lower Manhattan at the criminal courthouse, where he has to be in the courtroom by 9:30 a.m. as a criminal defendant. That is very tough, a very tough workday for the laziest president in history. Very tough way to start his day. Before he entered the courtroom today to observe the selection of jurors who will decide if his payoff scheme to porn star Stormy Daniels was criminal, Donald Trump testified about the evidence in the case, not under oath, of course, but into the microphones of the awaiting news media.
I was paying a lawyer and marked it down as a legal expense. Some accountant, I didn't know, marked it down as a legal expense. That's exactly what it was. And you get indicted over that? So check that out, legal expense. It's called legal expense. That's what you're supposed to call it. You get indicted over that. Nobody has ever seen anything like it. So thank you very much for coming. I'm now going to sit down for many hours.
The last line there was, and now we're going to sit down for many hours. And he meant that as hard work. That's hard work for Donald Trump, sitting down for many hours. That's not easy for him to endure at 77 years old. He doesn't do anything for many hours. And so, as reporters noted yesterday, Donald Trump's system just can't take it. Not for many hours. And Donald Trump, according to the observations of reporters in the courtroom, falls asleep. And so today, courtroom artist Jane Rosenberg took her place in the history of portraiture by capturing the sleeping Donald Trump. That makes Jane Rosenberg the first artist in history to create a portrait of a sleeping president or a sleeping former president, and is surely the first courtroom portrait in history of a sleeping criminal defendant during jury selection. When today's session ended 8 hours after it began, 8 long hours for Donald Trump, 7 jurors had been selected for the trial, 4 men, 3 women. Jury selection will resume on Thursday to complete the jury of 12 plus 6 alternates. Here's what we know about the jury so far. Donald Trump's jury foreperson is an immigrant. He works in sales now, but was previously a waiter. He's originally from Ireland. He gets his news from the New York Times, Daily Mail, sometimes Fox News, and MSNBC. Juror number 2 is a nurse. She gets her news from the New York Times, CNN, Google, and has a Facebook account. And when she was questioned, she said this, quote, "Especially in this courtroom, he will be treated as anyone else can be treated, and no one is above the law." She said she didn't have an opinion of Donald Trump before she walked into the courtroom. And then she said, "I am here for my civic duty. I'm here to listen to the facts." Juror number 3 is a man, probably around his 30s. He's a lawyer. and he gets his news from the New York Times, the Wall Street Journal, and Google. Juror number 4 is a man from Puerto Rico who said that he is fascinated, that was his word, fascinated with Donald Trump. We'll have more about what he said in just a moment. Juror number 5 is a younger, maybe in her 20s, black woman. She told Donald Trump's lawyer that as a person of color, she has friends who have strong opinions on Donald Trump, but she's not a political person herself. She said she tries to avoid political conversations and doesn't really care for the news. Juror number 6, a young woman, not sure what that age is, works with software. She enjoys plays, restaurants, dancing, and watching TV. That's juror number 6. Juror number 7 is a man. We don't have any information on that juror in the notes that I have on the jury that has been selected. Leading off our discussion tonight is Adam Klasfeld, who was in the courthouse today and who will be in the courthouse every day for us at the Trump trial. He's a fellow at Just Security. Also, Andrew Weissmann is with us, former FBI general counsel, former chief of the criminal division in the Eastern District of New York. He's an MSNBC legal analyst and co-author of the New York Times best-selling book, The Trump Indictments, the Historic Charging Documents with Commentary. And Adam, just fill in a blank here on that juror number 4 now, who said he's fascinated by Donald Trump. What else did he say?
No, I'm reading from the transcript here, Lois.
Oh, you got the transcript.
And
okay.
You have to imagine this real tone of wonder in this juror's voice, who's now on the panel, saying, I find him fascinating and mysterious. He walks into a room and he sets people off one way or another. I find that really interesting. Really? This one guy can do all this? Wow. That's what I think.
And what did the prosecutors have to say to that juror in questioning?
This was during an exchange not with the prosecutors, but with Todd Blanche. Because you have to remember, during this entire process, the court has studiously avoided trying to elicit from jurors, what do you think about Trump? Todd Blanche tried to push that in the pretrial hearings. Mm-hmm. That failed. And the judge said their opinions on Trump are immaterial. But during this process, during voir dire, Trump's lawyers have the chance to try to elicit that information. Elicit they did. And this one actually made the cut.
So, Andrew, each side at this point has used more than half of their preemptory challenges they can just offer without saying why. That juror coming in and saying, I'm fascinated by Donald Trump, he walks into a room. There's more than one way to read that, but that had to make the prosecution a little nervous listening to that.
So I'm struck by the fact that both sides have used 6 out of their 10 peremptory challenges, so they only have 4 left. There are 2 ways that juries can be chosen typically, and this is the one that's least gives the least amount of information to both sides. It's euphemistically called the flop method, and the other is called the strike method. The strike method is much better because you see all 38 potential jurors at once. Mm-hmm. You will see everybody who could be on the jury, and then you exercise your 10 peremptories, and the other side exercises their 10 peremptories. They don't have to, but that's up to 10. But you can see who the universe is. Here, you just do it sort of seriatim, so you don't know what's coming next. So what's striking to me is that there were at least 6 people who the prosecution and 6 people who the defense clearly thought they were so bad for them that they wanted to strike them. But it does leave both sides potentially vulnerable. And remember, what both sides are looking for is an anchor juror. They want somebody who's going to be so strongly for them, and then they don't really care whether the rest are sheep. That's sort of the general model. So when you only have 4 peremptories on each side, the potential of getting sort of somebody who's sort of strong one way or the other rises.
Yeah, and with only 4 left on each side, this means this could end up moving faster. And I just want to go back and double underline this point for the audience. It's so important because I think a lot of people out there think they hear a juror say something that they don't like, and they think, well, I would challenge that juror. And the answer to that is you might not if you have no idea who that juror is going to be replaced by. And that's the game they're playing now. They have,
exactly.
It's not like, oh, if I challenge that juror, then the next one up is Andrew. You don't know who the next one up is.
Right. Well, that's a terrible example. But yes, exactly. You don't see all 38 possibilities. So you have to exercise. And that's, to me, it's interesting that as the prosecution, they would exercise 6. It means they really didn't like them. At least that's what I'm sort of intuiting, because they have 4 for the remainder. Now, they won't care quite as much about the sort of the end alternates because the chances of getting to them are much lower. So they'll be focused very, very much on the next 5 is where they're going to really be focused, thinking that's the group of 12 then.
Adam, what else struck you during jury selection today?
Well, there was one point, and another piece of transcript before me, there was this one moment where the judge all but accused Trump of juror intimidation. What happened, there was a moment when the juror was called back into the room to answer for a social media post. She had posted a video that was around the time of the presidential election, around the time of Trump's defeat, and that it showed a street celebration. And I'm reading from the court about what the judge observed of Trump's reaction to her answers. The innocent explanation for that video said, "Before we continue, I want to put something on the record." This is Justice Merchan. "So, Mr. Blanche, while the juror was at the podium, maybe 12 feet from your client was audibly uttering something. I don't know exactly what he was uttering. He was audibly gesturing, speaking in the direction of the juror. I won't tolerate that. I won't have any jurors intimidated in this courtroom. I want to make that crystal clear." So that, of course, is an incredible moment. The accusation, we have to remember that Trump is still facing a potential contempt of court. There's a hearing scheduled for next week. He's been commanded to show up on pain of arrest. So when that moment rang out, it was an incredible moment in the courtroom. And the juror survived for cause challenge. The Trump team needed to strike her with a peremptory challenge.
That's one they had to use their challenge on. They had to decide. Yeah. Andrew, I want to go back to the evidence as presented by witness Trump to the press today. Something we'll never hear him say in the courtroom because he'll never testify. Right. But his defense that he's going to present every day in some version there outside of the courtroom is, listen, I was paying a lawyer. Michael Cohen was my lawyer. I was paying him for years. These checks to Michael Cohen were just me paying Michael Cohen, the lawyer. That's the defense. They're not going to get it from Donald Trump's mouth, but that's what the defense lawyers will be trying to get through cross-examination and other witnesses.
Yeah, so the clip you played was fascinating because he blew it. If you listen really closely, he starts by saying, and then he goes, oh, wait, no, the accountant did this. So it's like, wait, that's right. It wasn't I who did it. I have to say the accountant did it because then I can say I didn't know what the accountant was doing.
And he kind of pretends he doesn't know who the accountant is.
Yeah, I mean, but he wants to say whoever that is, I didn't really know. And by the way, whatever they wrote down was actually legal because it's like, it's fine to describe repayments of money to, hush money payments to a porn star as legal fees. That's one where, if you have a smart jury, which when I was doing this, I always looked for smart jurors. That's when I used to say, good luck to you. That I don't think is going to fly. But I just thought it was fascinating that he couldn't keep the story straight, which has got to be the accountant did it. I didn't do it. But he started out by saying, this is what I did. That is not going to be great. It'll be interesting to see whether the prosecution actually tries to use that because it's an admission. That tape that you just played is something that is potentially admissible.
And he's going to do some version of that pretty much every day out there.
Well, just to be clear, we saw that when Rudy Giuliani did that, and the evidence of what he said outside of court was played in the civil case, the civil defamation case that he lost. The same thing happened in the E. Jean Carroll case, where all those statements are admissible. They're admissions. And so this is one where you're seeing, again, no client control. And so he could really hurt himself. But, he only has himself to blame.
So, Adam, no Wednesday sessions in this trial, so no session tomorrow. You're back in jury selection Thursday morning.
That's correct.
All right, we're gonna pick up jury selection on Thursday. Adam Klasfeld, Andrew Weissmann, thank you both for starting off this discussion tonight. Andrew's going to stick around and join us with Neil Katyal later. Coming up, the scandal at the Supreme Court continued today with Supreme Court Justice Clarence Thomas participating in a case about the violent attack on the Capitol on January 6th, even though his wife was cheering Donald Trump on when he told his crowd on January 6th to go to the Capitol and fight like hell. Congresswoman Katie Porter was in the room today when the Supreme Court heard an appeal of a January 6th defendant of one of the charges against that defendant, which happens to be one of the charges Donald Trump is facing. Congresswoman Katie Porter joins us next. Joseph Fisher was a police officer in Pennsylvania in December of 2020 when he wrote in a text message, "Take Democratic Congress to the gallows. Can't vote if they can't breathe. LOL. It might get violent. They should storm the Capitol and drag all the Democrats into the street and have a mob trial. If Trump don't get in, we better get to war or we will lose our country." Police officer Joseph Fisher was at the Capitol on January 6th attacking police officers who were doing their job defending the building and the people in it. Joseph Fisher is facing 7 criminal charges for his violent attack on the Capitol. And today, the United States Supreme Court heard his appeal of one of those charges, obstructing an official proceeding. Joseph Fisher argues that that law does not apply to anything that he is accused of doing on January 6th. The law says whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding, or attempts to do so, is subject to prosecution. One of the charges pending against Donald Trump is that very same charge that Joseph Fisher is appealing to the United States Supreme Court. So, if the Supreme Court finds in Joseph Fisher's favor, they will, in effect, be finding in Donald Trump's favor, which means, once again, today, Clarence Thomas publicly deepened the scandal that he lives in. Clarence Thomas, of course, should have recused himself from hearing the case after his wife joined Donald Trump on January 6th when he was telling Joseph Fisher to go to the Capitol and fight like hell. Clarence Thomas's wife approved of every word Donald Trump said in incitement of the insurrection at the Capitol. And so Clarence Thomas today chose to publicly sit in judgment of a legal matter that his wife was actually involved in. We know from the January 6th committee that Clarence Thomas's wife was encouraging White House Chief of Staff Mark Meadows to break the law in any way necessary to overturn the presidential election when there was no legal method for overturning the presidential election. And not surprisingly, Clarence Thomas showed today that he doesn't think there was anything special about the January 6th attack on the Capitol, doesn't think it's any different from any other protest that we've seen in the past.
There have been many violent protests that have interfered with proceedings. Has the government applied this provision to other protests in the past? And has this been the government's position throughout the lifespan of the statute?
It has certainly been the government's position since the enactment of 1512c2 that it covers the myriad forms of obstructing an official proceeding and that it's not limited to some kind of evidence impairment gloss.
Have you enforced it in that manner?
We have enforced it in a variety of prosecutions that don't focus on evidence tampering. Now, I can't give you an example of enforcing it in a situation where people have violently stormed a building in order to prevent an official proceeding, a specified one, from occurring with all of the elements like intent to obstruct, knowledge of the proceeding, having the corruptly mens rea, but that's just because I'm not aware of that circumstance ever happening prior to January 6th.
Justice Sonia Sotomayor was not concerned about the lack of prosecutorial history.
We've never had a situation before where there's been a situation like this with people attempting to stop a proceeding violently. So I'm not sure what a lack of history proves.
Solicitor General Elizabeth Prelogar told the court that Joseph Fisher knew exactly what he was doing on January 6th.
One of the root problems with petitioner's conduct is that he knew about that proceeding. He had said in advance of January 6th that he was prepared to storm the Capitol, prepared to use violence. He wanted to intimidate Congress. He said they can't vote if they can't breathe. And then he went to the Capitol on January 6th with that intent in mind and took action, including assaulting a law enforcement officer, that did impede the ability of the officers to regain control of the Capitol and let Congress finish its work in that session. And I think it is entirely appropriate for the government to seek to hold petitioner accountable for that conduct with that intent.
Joining us now is California Congressman Katie Porter, who was a Harvard Law School student of Professor Elizabeth Warren and then was a professor of law herself. And Congressman Porter, you were in the Supreme Court chamber today listening to that argument. I feel I should be addressing you as Professor Porter tonight in your law professor role. You spent years as a law student studying Supreme Court cases and years as a law professor teaching Supreme Court cases. What do you make of today's?
It was incredibly impressive to see the way that the government's lawyer responded to a number of challenging and difficult questions from lots of different justices. One of the things that made me feel, as someone who deals daily with a dysfunctional Congress, is grateful that we still seem to have some amazing people working in our administration who are fighting to make sure that our democracy is protected. So it was a very, very pleasure to see the Solicitor General at work today.
It seemed to me, as I listened to the justices that have had issues with this law, it seemed to me that it was all about the 20 years. It was all about the fact that it can carry a heavy penalty, but of course, there's no mandatory minimum sentence attached to it. And you get the feeling listening to it, if this statute had just had a 5-year maximum sentence or less, that they wouldn't be there today.
And the punishment, the amount of sentence that something can carry, is irrelevant to the interpretation of the statute. Deciding what the punishment should be is actually Congress's job. The court's job, by contrast, is to understand how to read the statute and apply it to the facts, in this case, the extraordinary facts of January 6th. So I did take note of that they were focused on the consequences, very much on who these protesters were, on the peculiarities, the fact that we haven't had a situation like January 6th before. But look, we have had other kinds of criminals in our country try to disrupt our government and engage in things, whether it's witness tampering, threatening witnesses, destroying evidence, and trying to interrupt the certification of an election, to me, clearly falls under the statute at issue.
Let's listen to what the Solicitor General actually said about sentencing and what the sentences have been that have been issued in cases like this.
We've looked at the average sentences here. There are about 50 that have gone to sentencing, conviction and sentencing on just a 1512c2 as the only felony. So I think that's the best way to gauge it. This was when the sentencing enhancement did apply, so the ranges were higher. The average sentence among the approximately 50 people is 26 months of imprisonment, and the median has been 24 months. So there's no reasonable argument to be made that the statutory maximum here is driving anything with respect to sentencing. Also,
the other thing I heard from Justice Gorsuch and others was that attempt to compare what happened on January 6th to other forms of protest that seemed like they just didn't grasp the singularity of January 6th.
The justices asked a number of questions about other hypotheticals. For example, if someone were to interrupt the Supreme Court's own business, for example, and they had to adjourn, about other kinds of protest activity or disruption. One of the things the United States Solicitor General drove home again and again, which is incredibly important for Americans to understand, is the statute requires that the criminal defendant have acted corruptly, wrongfully, knowingly. So if we had somebody who was protesting, thought they were protected by the First Amendment, but they actually weren't, that wouldn't be covered by this. The emails from Mr. Fisher, the messages he sent about the gallows, sending Democratic Congress members to the gallows, all of those emails, all of that evidence is necessary to bring a case under this statute. So there are very, very strong protections here to make sure that somebody who's expressing an opinion, even an unpopular opinion politically, would never face prosecution under this statute. You have to intend to stop the government from conducting its official business and to be acting intentionally to do that.
Yeah, I have to say the point you just made, although the Solicitor General made it seemed like some of the Trump-appointed judges just ignored it, just didn't take it in at all. Congresswoman Katie Porter, thank you very much for that firsthand reporting from the Supreme Court today. Really appreciate it.
Thank you.
Thank you. And coming up, we'll have more on today's Supreme Court hearing next with Neil Katyal and Andrew Weissmann. At the Supreme Court today, it seemed like a majority of the justices were treating the 20-year maximum sentence for obstructing an official proceeding as if it were a minimum sentence, as if everyone convicted of that crime would automatically be sentenced to 20 years. In fact, the 20-year sentence seemed to be what bothered the justices the most about the law. Solicitor General Prelogar had to remind the court more than once that 20 years is, as she put it, just a max.
And again, the 20-year statutory max, of course, is just a max. There's no mandatory minimum. So Congress would have recognized that sentencing courts would use their discretion to tailor the actual sentence to the facts of that specific offense.
Joining our discussion now, Neil Katyal, former acting U.S. Solicitor General, who has argued over 50 cases before the United States Supreme Court. He's professor at Georgetown Law School and an MSNBC legal analyst, host of the podcast Courtside with Neil Katyal. And Andrew Weissmann is back with us. Neil, I have to say I was so impressed with the Solicitor General. It was a Katyal-like delivery there at high speed, jammed with content. But we're all eager to hear what you thought of what we heard today at the Supreme Court.
I am so proud of Elizabeth Prelogar. She was my associate for many years, and there's no one I think higher of. And today, Lawrence just demonstrated it. And I know that there's a lot of reporting out there that's like the Supreme Court is going to rule against the Justice Department, going to rule against her. I think that's somewhat premature at this point. I mean, I've seen over 500 Supreme Court arguments, and sometimes you know and sometimes you don't after the argument. I actually think this is more the latter. I think Donald Trump is hoping for a big bang that will nullify the statute. And I don't think he's quite going to get that. I think there are two separate issues. One is what Trump might get in terms of relief, and the other what his followers, like the litigant here, Fisher, might get. And, you know, I think the court was, in particularly Justice Barrett, was really entertaining the idea that, well, maybe the government's broad theory of the statute doesn't go quite this far. But so far, I didn't hear much of an answer to what Jack Smith has said, which is he has a narrower version of this statute that would allow the prosecution of Donald Trump. It may not allow the prosecution of some of the hundreds of others, but it would allow him because Donald Trump was focused on tampering with records, which is squarely within the heart of the statute.
Andrew, what is your sense of how this could impact the Jack Smith prosecution of Donald Trump?
Very similarly, which is that if there is a ruling in favor of Fisher, this is really saying that the statute requires that there be something related to documents, some kind of document destruction, creation of fake documents. And that isn't what was charged with respect to over 300 people. So this would have an enormous potential impact on people related to January 6th. However,
they would, if they ruled that way, they would get retrials?
They would get retrials in probably most of those cases. There'd be lots of arguments about, but I think generally speaking, that is what would happen. Some of those may be plead out. There may be other ways to charge them.
Because most of those defendants have other charges. And Fisher, for example, has other charges.
Exactly. Yeah. So if there are other charges, you could proceed on those. For instance, attacking a police officer or just entering the Capitol. I mean, there are a whole range of things. So it would mostly affect somebody who has only had that charge. With respect to Donald Trump, first, remember, he is facing 4 different counts in the January 6th case. This would affect 2 of them. But Neil correctly points out that and Jack Smith has said this directly to the court, which is that case, at the very least, involves this sort of fake elector scheme, which involves false documentation being used to obstruct Congress. So it depends how the court actually writes the decision. But, even on the sort of Fisher claim, and he was asked about this, he said, well, that's a harder case than his case. So Donald Trump really, he can be hoping, but I still think that's a sort of tough road for him. And I just want to say that I joined with Elizabeth Prelogar, was on the task force that Special Counsel Mueller worked on, and she was one of the legal team. Her preparation, it is really a sight to behold how much what you just played, how much she works on that to anticipate everything that she is going to be asked, and her precise wording is something that she goes over and over. So what you're seeing is something that is really a product of sort of intellect and skill and work ethic.
Neil, she has that speed. It comes out so fast and so focused. Neil, as we go forward here, what struck me was that many of the justices were really tough on the petitioner, and then they were tough on the Solicitor General. It's one of those cases where they were going hard against each side. And so at first I thought it was going bad for the petitioner, and then I hear, oh no, they really are coming at this from both sides.
Yeah, that's what you want, Lawrence, out of the court, is asking the tough questions to both sides. I do think it's like a little interesting if we were to step backward. How many times have Justice Alito and Justice Thomas asked questions about the fairness of a prosecution when it comes to a criminal defendant? Their jurisprudence not particularly known for that. So it's a little striking to hear so many of those strident concerns today coming out of that segment of the court. Similarly, think a dominant methodology of the court right now is textualism, reading a statute as just what its plain text says. Here, the plain text is so good for the government, Lawrence. It says it's a crime to otherwise obstruct, influence, or impede any official proceeding. And it sure seems like dollars to donuts, not just what Trump did, but what Fisher did when the other 300 defendants was to obstruct an official proceeding. It doesn't say anything about evidence and destruction of evidence in that particular part of the statute. And that notably is what Judge Pan, who wrote the Court of Appeals opinion, that's what she harped on, which was this is a standalone provision in a statute. It doesn't say anything about evidence destruction. And I didn't quite hear an answer to that in the oral argument today. So I know right now the reports are, the government will lose, maybe not lose, so almost certainly I think not lose the Trump prosecution, but might lose some of the hundreds of others. It's just not clear to me that anyone today took issue with what Judge Pan said in her opinion. And so that leaves me some hope to think, as it should, what these people did was illegal every day of every week, and they should be prosecuted and behind bars for it.
Yeah, I noticed that same point, Neil. And I have to say, just as someone who's actually written law, that is a very deliberate catch-all phrase that those legislators, those senators, those members of the House wrote into that law. Very deliberate. I know exactly the ways in which the staff sit there and get to that final one where they go, or otherwise make sure we've got something that catches everything we can't anticipate. Andrew, quickly.
It's worth noting that this statute came about because of the Enron case. Mm-hmm. This particular statute and 1519 were promulgated to be as expansive and as broad as possible. So for me, having worked on these statutes and the revision, was sort of almost ludicrous to hear these arguments, to have it be read in a way that is, as Neil said, counter to the sort of clear reading of the words. So again, I think this is a court that is doing whatever it can to sort of undermine these cases. You saw it in the disqualification decision. Hopefully you won't see it here, but there were obviously some justices who I think are very favorably disposed to reverse these. And then we obviously have next week the presidential immunity argument. So that's a trifecta that's really going to put I'd say the integrity of this court on trial.
Andrew Weissmann, Neil Katyal, thank you both, as always, for joining us on this important night. Really appreciate it. Thank you. And coming up, while Donald Trump spent today in a New York City courtroom on trial, President Biden was on the trail, kicked off a 3-day campaign swing through the very important Electoral College state of Pennsylvania. That's next.
We have more volunteers. We have more headquarters open. We have more people working for us. Look, we have over 1,600,000 people contributed to us. Many of here in Pennsylvania, tens of thousands of them. And guess what the average contribution is? Less than $200, less than $200, because almost 97% of all our contributions are from small donors. He hadn't opened a single headquarters here. We've opened multiple headquarters here. He has no presence here.
President Biden visited his hometown of Scranton, Pennsylvania today, which included a stop at his childhood home on North Washington Avenue. After a campaign event at the Scranton Cultural Center, there he is in front of his childhood home. And at the Cultural Center, President Biden said this.
When I look at the economy, I don't see it through the eyes of Mar-a-Lago. I see it through the eyes of Scranton, and that's not hyperbole. That's a fact. Where honesty and decency matter. Where faith matters. Where family is everything. Where we grew up knowing in our homes that Wall Street didn't build this country. The middle class built this country. And unions built the middle class. We know the best way to build an economy is from the middle out and the bottom up, not the top down, because when you do that, the poor have a ladder up, the middle class does well, and the wealthy still do very well. We all do well. There's a stark contrast from my opponent. He looks at the economy from Mar-a-Lago, where he and his rich friends embraced the failed trickle-down policies that have failed working families for more than 40 years. Scranton values are Mar-a-Lago values. These are the competing visions for our economy. Under my plan, nobody earning less than $400,000 will pay an additional penny. I hope you're all able to make $400,000. I never did. But they're not going to pay an extra penny in federal taxes. That's a promise.
With the president in Scranton today, the Biden-Harris campaign released a new ad about Scranton values.
Scranton is a set of values. We pride ourselves on the importance of family and honesty and hard work.
Joe loves Scranton because this was the beginning. President Biden is my first cousin, and there's almost like a part of him still here in Scranton. I do not believe that President Trump was for the little guy. He was for the wealthy. That was his lifestyle, and that's what he protected.
Trump is for Trump.
President Biden is setting us up for not just tomorrow, but for 50 years from now. We are so optimistic for the future of Scranton and continuing the work going ahead the next 4 years.
Joining our discussion now is the mayor of Scranton, Pennsylvania, Paige Cognetti, who was with the president today. Thank you very much for joining us tonight.
I'm so happy to be here. It's been an incredible day here in Scranton.
Well, tell us about it. What was it like to have the president visit?
Well, we're lucky here in Scranton. The president comes quite often. He loves coming home. I think you can see in his speech and the different shots of him today that he just really feels at home here. He's literally with his family when he's here. His cousins are here. He sees lots of his old friends and places, where he used to play baseball, where he used to ride his bike, and he loves to tell us those stories. So it's a great view of him and how authentic he is when he's here in his hometown.
That house he grew up in reminds me of the second house I grew up in when we moved up to a bigger house in Boston, in a neighborhood similar to that one, looks similar to that one. It must really mean a lot to him to be there.
It does. It really does. And it means a lot to us in Scranton. And as we drove from the airport to the city, there were people lining up in the streets, and that continued all night. So it was a long day, of course, as these visits go. And it was, 8 o'clock at night. We're driving in the motorcade back, and the streets were lined with people, kids with signs waving. It was a great moment for our city. It always is when he comes back. But there really was something special today. I think, you've got this bright, sunny, beautiful day, and that we've got the campaign going. People really want to see the president continue to lead our country. They want to see him continue to lead the economy. We still are struggling at the household level. We've got this great macro picture, the global economy, America is dominating, we're firing on all cylinders. But at the household level in cities like Scranton, folks are still trying to figure out how to pay increasing, utility bills, increasing rent. And President Biden's thinking about that. He's from a place like that. He's from a kitchen table just like that. So they know that those types of policies that he's thinking about day in and day out are going to benefit them. And it's our job to keep talking about it.
Out in the western part of the state, which is a Republican part of the state, the president has been surprised by some things he's seen. Let's listen to one thing he talked about that he saw out in that part of the state.
I've never thought I'd see a time when I'm going through a neighborhood or a rural town in the West or something and see big signs that have a Trump sign in the middle that says F. Biden, and having a little kid standing with his middle finger.
That is pretty poisonous stuff, and that is a creation of the Trump era.
It is. And we've seen a real shift, right, in what people are willing to say out loud. And we see it right here in Scranton. I've seen it in our city government, where these last few years there's been this divisiveness from the public. And it's not a majority of folks. It's a small group. But you see that willingness to say out loud some of the nasty things that people read online. And you see, that people are calling into our office and saying things that they wouldn't have said just a handful of years ago. So we've got to fight through that. We've got to fight to make sure that we are continuing to be decent in America, that we're continuing the policies that give people dignity. And that's what Joe Biden brings, right? He thinks about dignity. Today, he was here talking about tax fairness, right? That's so important that we continue to be the America that we are and put that to our children and make sure that they know that they can look up to heroes, look up to people like Joe Biden. Donald Trump does not offer that type of leadership. We know that. He tells us who he is all of the time. Something the president said today was listen to him, listen to him. He is telling you who he is. It was the first time I heard the president say it so simply, and I really like that. And we've got to make sure people are listening to both sides and making that choice.
Mayor of Scranton, Paige Cognetti, one of Joe Biden's favorite mayors. Thank you very much for joining us tonight.
Thank you, Lauren.
Thank you.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.